Hello and welcome everyone to PW Only IAS English. In this lecture under Udaan series for Prelims 2025, today I, Jatin Verma, am going to take you through the President and Governor's Office, the comparison of the ordinance making power of the President, the veto power of the President and the like. So let's get started. First thing first, in the previous class we saw the election process of the President of India. What is the oath of the President of India? What are the duties of the Prime Minister vis-a-vis the President of India to keep him informed under Article 74, under Article 78 and the like. So here today we are going to start with the veto power of the President of India. Veto simply means the power of the President to block any bill of the Government of India, of the bill that has been suggested by the cabinet because of the following reasons. The reasons could be the bill is not in sync with the constitutional norms, or the legislature or the government has lost the majority in the parliament. So these could be the grounds, or the provisions of the bill are in conflict with the constitutional provisions, as I said. So here absolute veto, qualified veto, suspensive veto, these are the three powers available to the presidents in general. Okay, four powers including the pocket veto. Indian president has got three powers: absolute veto, suspensive veto and pocket veto. He can in ordinary circumstances give the signatures to the bill, and then the bill becomes the law. Okay, but there are certain cases where he thinks that the bill is not in sync with the constitutional requirement. For example, office of profit bill introduced during 2005-6, APJ Abdul Kalam sir had rejected it on the grounds that office of profit exempting Sonia Gandhi from the office of profit was not in the right scheme of things as per the constitution. Okay, so these type of the grounds can be there. Then there are certain categories of bills which require the prior permission, prior approval of the President of India. We are going to talk about those also. So here Article 111 deals with the President's veto power over a bill passed by the parliament. Okay, then there is Article 201 which deals with the power of the president to veto the bills passed by the state legislative assembly in case the governor reserves the bill, or in case the president can ask the governor, president asks the governor to reserve the bill for the consideration of the president. So these can be the grounds. Okay, Article 111, veto power of the president vis-a-vis the bills of the union parliament, the central parliament, or 201 vis-a-vis the bills of the state legislature passed by the state legislature, reserved by the governor, or sought to be reserved by the president. So these can be the powers under these two articles. Okay, now veto power, the President of India enjoys these three veto powers. Qualified veto, the fourth power, is observed in the countries like US. Okay, whereby a time limit is there, or you can within that time limit or after that time limit, the parliament, the US Congress, can pass the bill with a higher majority. That kind of a thing is not observed in India. Higher majority is not required. If in case the president rejects the bill, that means exercises the absolute veto, the Parliament of India can pass the bill again, this time again with the simple majority. So that is why we do not have qualified majority in our system, in our constitution. Absolute veto refers to the power of the president to withhold his signatures assent to the bill passed by the parliament, and he notifies this that he is exercising, he is rejecting the bill. Okay, in case of a private member bill, ordinarily absolute veto would be exercised by the president in case of a private member's bill. For example, any member of parliament who is not a minister, even though he belongs to the ruling political party also, if he introduces a bill and that bill by chance happens to pass through the union parliament, Lok Sabha and Rajya Sabha, and lands at the table of the president, then also the president can reject that. Second, in case of the government bill, like in 2014, what happened? The outgoing UPA government had introduced three bills: Lokpal bill, then Whistleblowers bill. All three bills were passed through the parliament. They were able to pass through the Lok Sabha and Rajya Sabha. But then, as the then president Pranab Mukherjee could sense that the government may not be able to win, or he out of his own conscience considered it right not to sign on these three bills until the new government takes over. So after 2014, BJP government decided not to proceed ahead with the bills. For example, okay, if they would have decided to not to sign the Lokpal bill, to not to make the Lokpal bill into a law, not to pass the Whistleblowers Act, so they could have advised the president to exercise absolute veto, or president can out of his own discretion exercise this absolute veto also. Okay. Suspensive veto. The suspensive veto refers to the power of the president to return a bill for the reconsideration of the parliament. If the bill is passed again by the parliament with or without amendments, sometimes the president would suggest amendments. If the bill is passed without amendments also, then also the president is duty bound to sign the bill. Okay, the president has to either give his assent or withhold his assent to a money bill. We'll talk about money bill also. It is obligatory if in case the bill is passed once again without amendments in the same format, in the same shape, then also the president is duty bound, because president is not the real head of the country. Okay, he is just a figurehead. So that's why. Okay, it is to be noted that suspensive veto is not available in case of money bills. The president has to either give his assent to the bill, withhold his assent to a money bill, but cannot return it for the reconsideration of the parliament. He cannot ask that reduce the expenditure on Pradhan Mantri Awas Yojana or Samagra Shiksha Abhiyan or the like programs. He will have to either sign it or reject it. Okay, but he cannot return it for reconsideration. The only technicality is that he cannot write on the bill that he wants the parliament to reconsider it, because it is a money bill and the elected government has got the right to write on the treasury of the country. Okay, right on the consolidated fund of India. Then coming to pocket veto. Pocket veto refers to the power of the president to neither ratify nor reject it. He simply keeps the bill in his pocket. Okay, so simply keeping the bill pending for an indefinite period of time. There is no time limit. Okay, in the US there is a time limit of 10 days, that within 10 days if the president does not sign the bill, then it is assumed, it is considered that he is exercising pocket veto. Okay, so therefore the US Congress can pass the same bill again after the lapse of, after the completion of period of 10 days. But that is not the case with Indian system. In Indian system, there is no time limit prescribed. That is why it is said that the scope of the pocket veto of Indian president is wider than the scope of the pocket veto of the US president. Okay, so 10 days technicality, pocket veto, there is no time limit. There is no 10 written, no number of days written on the pocket of the president when he exercises pocket veto. This is how you can memorize this also. Now, salient points to be noted for prelims here. The president has no veto in respect of constitutional amendment bill. Okay, why? Reason is simple. The special majority is being wielded by the is being used by the parliament. So when special majority is being used by the elected representatives of the people, why would the president be exercising? Why would the nominal head be exercising veto over it? Okay, 24th Amendment Act 1971 made it obligatory for the president to give his signatures to a constitutional amendment bill. Even though the later acts like 44th Amendment Act, like Judicial Review, Keshwanand Bharti case, they undid the damages done to the constitution by 24th Amendment Act, 38th Amendment Act. But this provision that it is obligatory for the president of India to sign the constitutional amendment bill still remains in the constitution. Okay, 44th Amendment Act brought about by Morarji Desai government did not amend it, did not repeal it, repeal this provision. Thereby, this still survives. Now, the difference between absolute and pocket veto, many a times the students, they get confused. Absolute veto, when the president is outrightly rejecting the bill. Pocket veto is when he is not expressing anything, neither signing it nor rejecting it. So there is a difference of only the technicality. Absolute veto is he is expressing that he is not going to sign, thereby opening the door for the parliament to repass the bill. Okay, but in case of pocket veto, indefinite suspense gets created. Okay, the dilemma gets created. So that is the difference between the two types of vetoes here. Veto power of the president over state legislature. As I said, this is Article 201. Okay, if a bill is passed by a state legislature, has been reserved by the governor for the reconsideration, for the consideration of the president, then the bill can become an act only if the bill receives the signatures of the president. Okay, even if the bill is passed again, then also governor loses any control over the bill. All that the governor can do is to send the bill to the president. Thus the president has been given the veto power with respect to the state legislative assembly bills in this manner that he gets the complete control over the bill. Okay, now it is mandatory for the governor to reserve the bill for the consideration of the president if the bill is having any clash with the bill already passed by the parliament on the concurrent matters. Okay, for example, POCSO Act, Protection of Children from Sexual Offences Act. If a bill of 2000, if the Act of 2012 passed by the Union Parliament is already there, and if the state of Haryana, for example, passes a bill diluting this POCSO Act or strengthening this POCSO Act, in the sense that anybody under the Protection of Children from Sexual Offences Act, if in the state of Haryana commits any offence of molestation, rape, etc., against a child of age less than 12 years, he can be hanged. He should be given death penalty. But this provision was not there in the concurrent law, in the parliamentary law, POCSO Act 2012. So, Governor of Haryana had to reserve this type of a bill on which a legislation has already been made by the Union Parliament for the consideration of the president. Right. Second, if the bill abrogates or in some way or the other compromises with the power of the state high court, then also it is obligatory for the governor of a state to reserve the bill for the consideration of the president. Clear? Well, it is the choice of the governor. As we see in case of Tamil Nadu, many bills are being reserved by the almost every bill is being reserved by the governor for the consideration of the president. Well, that is Indian democracy at actual work. Okay, we are reading the theoretical part for the sake of our prelims 2025 preparation. Now, the options before the president: he can give his signatures to the bill, he can append his assent to the bill, he can withhold his assent to the bill. Okay, this gives the president the absolute veto over the state legislation. Third, to direct the governor to return the bill. If it is not a money bill, then only. So that means money bill duly passed by the state legislative assembly can also not be returned by the president. Okay, he cannot direct the governor to return the money bill, as in the case of Union Parliamentary Money Bill, in the same manner, the state legislative assembly money bill can also not be returned. However, it can be rejected. Okay. This third thing, this gives the president the power of suspensive veto. So the president has got absolute veto. Okay. Then the power of returning absolute veto is abruptly, altogether rejecting the bill. Okay. Second thing is to withhold his assent. Third thing is suspensive veto. Okay. Even if the bill is passed again, as I said, it is not obligatory for the president to actually sign the bill. He can withhold his assent to the bill even then also. The state legislature this way cannot override the veto power of the President of India. However, by passing the bill again, the state legislature can seek to override the veto power of the governor of the state under Article 201. Okay, under Article 200. But in that case, in the second scenario, if the bill is passed again, please try to understand, if in the first case, bill passed by the state legislative assembly is returned by the governor, state legislative assembly passes the bill again, then in that case, the state legislative assembly, the governor can the second time reserve the bill for the consideration of the president. This is the unitary feature of the constitution, giving upper hand to the agent of the center, that is the governor. Okay, this is what has happened in Tamil Nadu. The state legislative assembly repassed the bill thinking of the governor exercising the suspensive veto. not doing anything over the bill. Okay, then they passed the bill again. When they passed the bill again, governor referred the bill to the president. So this is the problem. Now, comparison of the veto power of the president over central and state legislation. With regard to ordinary bills, he can give his assent. He can give his assent to the state legislation also. Can be rejected. Absolute veto can be rejected. He can reject the state legislative assembly bill. Can be returned. Suspensive veto can be returned. Okay, but can the money bill be sent for reconsideration? We are talking about the reconsideration. Okay, suspensive veto, no. With regard to money bill, no. Okay, we'll talk about the money bill next. Can be kept pending. Pocket veto can be kept pending. So he can keep the parliamentary law duly passed, parliamentary bill passed. He can keep it on his table until abeyance. Okay, so this is there. Now, with regard to money bill, can be ratified, can be ratified, can be rejected, can be rejected, but it cannot be returned. No suspensive veto with regard to money bill in both the cases. Okay, now cannot be kept pending. No pocket veto with regard to money bill. Okay, can neither be returned, cannot be kept pending. Either accept or reject. Only the first two options are available. Okay, take a note of it. Emphasis added. Now, moving further, ordinance making power of the president. The ordinance making power of the president of India is a distinctive feature which is not found in the constitutions of UK or US also. Okay. So the constitution makers wanted that in case the parliament is not in session, under Article 123, it gives the power to the president to pass a temporary law that we call as ordinance. Okay, when the parliament meets next, it has to approve the bill passed by the, it has to approve the ordinance passed by the or signed by the or promulgated by the president within a period of 6 weeks from the date of first sitting of both the houses. If Lok Sabha sat on 14th of February, okay, and if Rajya Sabha started its sittings from 16th of February, okay, then from 16th February a period of 6 weeks will be counted, shall be counted. Okay, a period of 6 weeks shall be counted from the later of the two dates. Which is the later date? This date, because the bill has to be passed through both the houses. So latest of the later of the two dates shall be considered, from which the 6 weeks shall be counted. Now, as per the constitutional requirements under Article 85, Article 85 says that there shall be no gap of more than 6 months. It is the duty of the president to ensure that within 6 months the session of the parliament happens. Okay, for example, if the budget session is happening now, then monsoon session will happen in June, within 6 months. So the maximum time period for which an ordinance can survive can be 6 months and 6 weeks. Okay, so 6 weeks from the date of first sitting, that period starts. Within that period, the parliament has to approve the bill. Misuse of the bill has happened many a times. That is why misuse of the ordinance provision has happened many a times, that just days before the start of the parliamentary session or just days after the recess of the parliamentary sessions, the ordinances have been promulgated to bypass the legislative, to bypass the parliamentary scrutiny of the bills. Okay, to not to let the bill be discussed in the parliament. So repromulgation of cases has happened, repromulgation of ordinances has happened, to the extent that in DC Wadhwa case, DC Wadhwa versus State of Bihar, the Supreme Court had to say that repromulgation of ordinance is a fraud on constitution. Okay, so then Cooper case, RC Cooper case, we are going to talk about. That statement of objects and reasons has to be laid before the houses of the parliament, that what were the reasons that warranted such a hasty passage of ordinance, such a hasty step on the part of the executive. Okay, now I ask you a simple question: is ordinance making power of the president a legislative power or an executive power? Why ordinance is called as executive action even though it is legislative power? If you have the answer, please genuinely answer this question. I'm genuinely speaking. I will correct it in the comment section itself. Now, I'll correct you if you happen to be wrong with in terms of your explanation. Ordinance making power of the president, limitation is the ordinance making power of the president is not extraordinary power. it is coterminous with the power of the parliament to legislate upon on the subjects and on the subjects given in the union list or the concurrent list. Okay, so this is one thing. Another thing I would like to tell you here is the decisions taken by the government, the decisions taken by the private players, citizens under the ordinance, okay, would still be valid if in case the ordinance lapses. Many ordinance bills are introduced, many of them are not even introduced. So, whatever decisions as the citizens under the good faith we take, any private company, if it brings in the FDI under the relaxed FDI ordinance bill or FDI ordinance, will that FDI be considered illegal after the ordinance lapses? No, that will survive. Okay, that will be held to be valid. That decision of Amazon, that decision of any foreign company will be held to be valid even if the ordinance does not see the light of the day. Ordinance bill does not see the light of the day. Okay, what is the difference between ordinance and ordinance bill? The provisions of the ordinance, when framed into a bill, it is called as ordinance bill. Okay, four key limitations. Parliamentary sessions. The president can promulgate an ordinance only when both the houses of the parliament are not in session or when at least one house is not in session, as legislation requires approval from both the houses. Okay, so both the houses are to be there. Justiciability. In Cooper case 1970, 38th Amendment Act had said that the judiciary cannot review the ordinance. Okay, whether it is valid, invalid, whether it is passed with the ordinances promulgated with a mala fide intention, these reasons the judiciary cannot go into. Okay, but in RC Cooper case 1970, Supreme Court said that judicial review is an essential tenet of constitution, is an essential part. Okay, so anything and everything done indirectly or directly has to be run through the judicial review. You cannot exclude ordinance merely because it is an executive action of the president. Okay, since it is given in the constitution, judiciary has got the power to review anything that is constitutional, anything that is done under the constitution, so they will review it. Now, initially 38th Amendment Act 1975 made the president's satisfaction non-justiciable, but this provision was automatically, on its own, repealed by the good sense that prevailed upon the Morarji Desai government of 1978. Okay, 44th Amendment Act repealed it on its own. Right. As a result, the challenge based upon mala fide intention remains valid. And not only this, the president can, the president has to lay the papers labeled as statements of objects and reasons. So these type of questions, sometimes static and current, they are blended together. So you should be knowing about the other provisions also. Okay, duration and validity of the validity constraints. So we are discussing the limitations. Limitation number 1 we have discussed, limitation number 2 we have discussed, limitation number 3 we are turning to. Duration and validity. President's ordinance making power is not, the ordinance is not going to be eternal in nature. Ordinance can survive for a maximum period of 6 months and 6 weeks. Number 1. Then validity. Ordinance can be promulgated only when the parliament is not in session. We are in a way comparing the ordinance making power of the president with the law making power of the parliament. Okay, parliament has the power to make the legislation upon any subject. Okay, given in the union list or concurrent list. So has the ordinance. Same power is there with the ordinance also. But the only constraint is ordinance can be promulgated only when the parliament is not in session. Number 1. Number 2, the other constraint is maximum lifespan. The shelf life of ordinances 6 months and 6 weeks. Done. Now, limitation, maximum validity period, we have talked about it. In between 6 months and 6 weeks, if it seems to the parliament, if it seems to the union executive that ordinance has served its purpose or it is no longer needed, it can be annulled earlier if both the houses pass the resolution disapproving it. Okay, so president can withdraw the ordinance on its own. Yes. Can the parliament annul the ordinance if it thinks that it is ultra vires or it is extraneous, it has been promulgated on extraneous grounds? Yes. Okay, so ordinance can be withdrawn by the president on its own. Okay, so this is the limitation upon it. Ordinance making power 123, ordinance making power of the governor compared over here. So in this lecture, in a way, we have tried to cover governor's powers simultaneously, because many a times the questions that have been asked from this area, president and governor, they seem to be match the I mean, comparison type of questions have been asked. So comparing the powers of the governor by juxtaposing them to that of the president is the right way of studying this topic. And yet at the same time, we should not be losing the sight of individual powers just for the sake of comparison. Got my point? So ordinance making, president can issue ordinance when both the houses of parliament are not in session, or the governor can issue an ordinance when legislative assembly, state legislature, either bicameral or unicameral, both are not in session. Okay, so uh, so promulgate an ordinance only if he believes that immediate action is required. Again, immediate circumstances are required for the governor. The ordinance making alliance with the parliament's legislative authority. Here also, the ordinance making power of the governor is coterminous with the legislative powers of the state legislative assembly. Okay, done. Then through ordinance you cannot do anything that you cannot do directly. It does not give any Sudarshan Chakra or Brahmastra kind of powers. Only those powers which are ordinarily vested in the state legislature or union parliament respectively are vested in the governor and the president. Okay, now an ordinance issued by the president carries the same authority and impact as the law passed by the parliament. Even after it lapses, the decisions, the actions taken by the private individuals, by the government authorities, IAS officers, ministers would still be held to be valid. An ordinance issued by the governor has the same force, so no difference. Invalid if it includes the provisions the parliament cannot make. True for the governor also. Can revoke an ordinance at any moment, can withdraw the ordinance. So president and governor can in their own domain withdraw these ordinances at any time before they are presented to the parliament in form of the bill. Okay, now pardoning power, coming to another important power, power to pardon. So we all know that the president has got exclusive powers with regard to the court martial, the sentence by an army. Okay, AFSPA Act or other acts likewise. Court martial is different from AFSPA though. We will talk about it in the relevant lecture. The sentence involves capital punishment. What do we mean by capital punishment? It means death penalty. The conviction is for offences under union laws. The president has got exclusive power to pardon a sentence which is granted under union law, as happened in the Rajiv Gandhi case, okay, or union law case. That makes me remind and help you, if the case is investigated under the central law or investigated by central agency, okay, law or agency. So in Rajiv Gandhi case, even if the crime happened in the common law common to both the center and the state, CRPC, and the crime happened in the jurisdiction of Tamil Nadu government, then who would pardon that sentence? The answer was the sentence will be pardoned by that institution, that level of government whose agency investigated it. So since agency was Central Bureau of Investigation, the pardoning power, the pardoning of death sentence or reduction of death sentence was, or even you can say the overall reprieve, respite, anything, commutation also was in the hands of the president. Okay, but the governor exercised it in the sense that the crime happened in the state territory of the state and happened under CRPC, which is a common law subject, concurrent law subject. Now, significance, this power ensures that the president can remedy the potential judicial errors. Judiciary sometimes is blind to these social context of the criminals. That is why the eyes of the statute of law are blindfolded. कानून की आंखों पर पट्टी बंदी होती है, as they call it in Hindi feature films, right? So eyes of the statute of law are blindfolded. Sometimes the judiciary may not be able to take into account those extraneous factors which are legitimate. Okay, so this is their limitations. The president cannot exercise this power independently. Decision is on the aid and advice of Council of Ministers under Article 74. Done? Now, what are the various types of these clemency petitions? Clemency means the prayer to the president. Petition means the prayer to the president to grant some respite, to grant some concession in the lawfully given sentence, in the sentence which is given, in the punishment which is given otherwise lawfully. Okay, so grant some respite from that. So here, pardon removes both the sentence and conviction. That means if an IAS officer is there, or if an MP or MLA is there, if or a UPSC aspirant is there, if there is a criminal taint, if there is a black spot on your attire, then you are ineligible from holding certain government positions. Pardon is the best kind of concession, clemency, that you can get. That gives you relief from the sentence, that makes you as pavitra, as pure as if you have never committed that crime. Okay, as if you have taken the bath in the holy waters of Mahakumbh, right? As if you've never committed the crime. Revokes both the sentence and the conviction, absolving the convict from all punishments and disqualifications. Commutation means substituting one form of punishment with another, considering some circumstances, etc. For example, rigorous imprisonment to simple imprisonment. In rigorous imprisonment, you have to do some manual labor work in the prison, breaking, stones, etc., working in brick kiln, etc. So those things will be done. Remission reduces the period of sentence without changing its nature. 10 years rigorous imprisonment. In this case, for example, 10 years rigorous imprisonment reduced to 7 years of rigorous imprisonment. Done. Then respite awards a lesser sentence due to special circumstances like physical disability or pregnancy. Respite, remember, rains give respite from the scorching heat. Okay, so here, by lessening the heat, by lessening the sentence, you are, what are you doing? Because people are, the convict is not able to bear it considering the special circumstances, so this is called respite. Now reprieve temporarily stays the execution of a sentence to allow time to seek pardon or commutation. For example, if a person is to be hanged tomorrow, the 28th of February, we are standing at 27th of February, but if that sentence is not not given a temporary hold, not given the reprieve, he would be executed tomorrow 7 a.m., the 28th of February. So as to give him the time to apply for pardoning, reprieve is used. Okay, reprieve can be applied for, can be sought for from the president or the governor. All right, can the governor give reprieve in case of a death sentence? Yes, so as to enable the president get the sufficient time, so as to enable the convict who is to be hanged the next day, give him sufficient time to reach out to the president's office. Reprieve can be given by governor also, even if it is death sentence. Now, governor of a state exercises pardoning power under Article 161. Governor can pardon, reprieve, respite, remit, suspend, or commute the punishment or sentence anyone has got under the state law, only the state law. The governor can suspend, remit, or commute a death sentence, but not pardon it. Okay, the president can pardon in case of pardon the cases involving court martial, but Article 161 does not grant this power to the governor. So this is a brief comparison of the power of the governor and that of the president. Done. Now, comparing the pardoning power, president can pardon, reprieve, respite, remit, suspend, or commute the punishment. Governor can pardon, reprieve, respite, remit, or suspend or commit punishment or sentence of any person against a state law, against central law only. President, okay? He can pardon, reprieve, respite, remit, suspend, or commute a death sentence. He is the only authority to pardon a death sentence in the country. Then he cannot pardon death sentence even if the state law prescribed for the death sentence. Then also governor cannot pardon the death sentence. This power lies exclusively with the president of India. Okay, but the governor can suspend, remit, or commute a death sentence. Complete pardoning is not allowed. Completely absolving a person, okay, please go free, you are let loose, that power is not there. But giving respite, suspension is allowed. Okay, now he can grant pardon in case of court martial. The president has got the power. He does not possess any such power with regard to court martial. Governor does not have any power. Done. Now, Emergency powers, we have seen the emergency powers earlier. So here's a snapshot for quick revision of emergencies that can be issued by emergency notifications that can be issued by the President of India. All right. For any doubts that you have with regard to this topic or any other topic that we've covered so far, feel free to reach out to me. Okay. So through the comment section, we actively go through all the comments or the doubts posted on my Telegram channel, which is connected to a group. So you can reach out to me there also. The link of the Telegram channel or group is given in the description box. Now, executive powers, we have already seen the executive powers of the president: appointing a commission, appointing the members of UPSC, constituting Union Finance Commission under Article 280 after a gap of 5 years, after at a gap of every 5 years, okay, appointing the commissions for SC, ST, and NCBC, National Commission for Backward Classes. All those things are just the reiteration of those important yet simple provisions. Okay, so this is there. Now, coming to the governor, Article 153 says that there shall be a governor for each state. He is the constitutional head of the state, nominal head of the state, bound by the advice of Council of Ministers under Article 163. Okay, he is a vital link between the union and state governments. So these articles we've already covered. Governor assents, withholds, or reserves the bill. Article 200 is the power of the governor with regard to the bill. Veto power is contained in Article 200. Article 201 deals with the veto power of the president with regard to the bills reserved for him by the governor of a state. Am I clear? So these are very easy provisions here. This was all in today's lecture, guys. So this completes our chapter, the president and the comparison of the powers of the president with that of the governor. Okay, governor constitutional provisions are there. One important thing, can the same person be appointed as the governor of more than one state? 2 states, 3 states? Yes. If yes is the answer, yes, answer is yes only. Which article deals with it? Please answer it in the comment section. I'll be coming up with another lecture on Saturday, which will be of a longer duration to help you cover, to help you revise things in a streamlined manner. How you're finding this Udaan series to be, please let us know through your comments in the comment section below this video itself. Thank you. We'll be meeting again, keeping you updated through the polity lectures for your prelims 2025. Thank you. Bye-bye. Have a good time ahead.